there's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. We agree with 3 guns in that car, another gun in this car. If he got 8, then I would consider that. But at this point, I'm over all of this gun stuff. This is the last opportunity you're going to be given here. You've been given a whole lot of opportunities. Of the 2nd-degree felony offense of aggravated assault with a deadly weapon, sentence you in accordance with your agreement to a term of 8 years in the. Right, are you Jameldrin? Yes. Willridge? So we're here. Mr. Willridge has 3. He's on probation in 3 cases: 18-28743, 28744, and 30139. And then there's a new offense of burglary of a habitation in cause number 25 DCCR 1804. And there was an agreement that was reached, and he entered a plea of guilty to that burglary of a habitation case. The agreement was for a 10-year deferred probation, restitution to be determined, and that those motions would be dismissed. There was an issue between, obviously, when he pled and now, which required me, I revoked that bond because he was arrested on May 26th in Chambers County for a 3rd-degree felony and a Class B misdemeanor. So obviously that
kind of nullified from all of our position where we were with that agreement, Judge.
Right.
So you know.
Okay. So where are we? I mean, I'm going to at this time reject the agreement formally so we can start all over. You guys negotiate whatever y'all want to do. If we need to get more information about that Chambers County case, but obviously I'm not inclined at this point. I see no reason, if those allegations are true, that Mr. Wilbridge would get another opportunity on 3 felony probations with now the new burglary of habitation here. And while literally days after he entered pleas here, went and was at a minimum in a county that he wasn't supposed to be in without permission and arrested for those offenses. So my thought is, do you have any information on those yet?
No, Judge, because when we broke last night, it was primarily, obviously not knowing that was going to happen in Chambers County, for the restitution in the burglary. Because we all had the discussion about how could tennis shoes cost that much.
Right.
And I have spoken several times with Mr. Riley, who the court knows is an excellent PSI writer. And he assures me, and through an affidavit from the complainant in that case, that that's what the restitution amount is. So I feel like we could ask for that and see if he'll pay it, and so be it. Then obviously the new offense came up, which then put us all kind of back at square one. The court is aware that I have always been a little bit more outgoing with Mr. Wildridge, wanting to give him an opportunity. I'm not suggesting I still don't want to do that, but I certainly understand the position that we're all in. I mean, the files are just stacking up.
Yeah.
And
I mean,
and Judge, only thing I can say in that regard is that, you know, of course, I've dealt with him for a long time in the situation, and, you know, he understands it was inexcusable for what happened in Chambers County. But I will say that it's the first time that since then that he's actually opened up to me as far as asking for the type of help he needs for any underlying issues that may be there. And it's something that his family was actually in the position to try to get started when the whole bond situation occurred, but of course he turned himself in, you know, did what he's, you know, complied with your orders.
And that, per our conversations, I think, Judge, it's important to note that that has to do with underlying mental health issues that go directly in correlation to his behavior. Although it doesn't excuse his behavior.
No, it doesn't. And I guess, I mean, you guys know, I mean, he's been on probation since 2018.
Right.
There's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. It's been years that we've gone through motion to revokes that have been dismissed. And
I mean, the only thing I can say is a lot of times in these type of situations, of course, the help doesn't work unless the person is ready for it. And of course, like I said, this is the first time he's opened up to me as far as trying to get that. And a good thing for him, he does have the support system there that he can try to get that help.
And that's so great. And it's also such a shame at the same time, because I'm guessing he's had the same support the whole time. It's not like people are just now stepping up and saying, let's help him out. Right. I mean, they've been there the whole time. And here we are with our 5th felony in Chambers County while you're on probation for 3 here. Here's what I need. I'm not going to do anything today. I want to find out, see what you guys can find out about Chambers County, what the status of those offenses are. Get Mr. Lewis whatever you can, so that I can also have a little, even if it's just a PC, so I can see a little more about what the underlying offense allegations are, and then we can kind of reconvene and I do see, I guess, where if you guys want to try to tell me what some agreement is, I'll see if I'm willing to go along with it or not. Obviously, probation, I value your opinion, and so
More likely than not, Judge, if it's okay with the court, probably will not come to you with any type of agreement, maybe just more of a conversation. Obviously, we're all aware of the situation that all of us are in right now with respect to individuals this age that have been given multiple opportunities and what else going on. So
we're also going to go through, we can do it. I don't know, there probably needs to be amended motions on those 3
to add those.
to add those allegations, and I'm not going to just sign a dismissal on those motions. I want to go through each and every allegation of the motion, get pleas of true or not true, and then we'll go forward. So between now and then, if you can get, I guess, any type of hearing done so that we can get those new allegations in the hearing, in the motions to revoke, we'll go through those at the next court date, and then we'll see where we are from there.
You get that.
Okay.
Problems with.
All right. Thank you. Go back to the bailiff. Good morning. Are you Kenneth Harrison? And will your client waive the formal reading of the motion?
He does, Judge.
Mr. Harrison, in cause number 24 DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first degree felony offense of aggravated robbery. And that was a 10-year deferred probation. Is that correct?
No.
The motion alleges that you violated your probation Count 1 alleges that you failed to report as directed on or about March 31st of 2026. Is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, I can abandon 4, 5, and 6. We can skip to 7.
Count 7, let's see, state abandons 4, 5, and 6. Count 7 alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true?
True.
Count 8 alleges that you associated with a convicted felon and disreputable person on July 13th of 2025, and that you were stopped by the Port Arthur Police Department with Roderick Randall, a convicted felon, and that he fled on foot while possessing a weapon. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 3, 7, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Well, give me just a second.
Your question would be the underlying offense, Your Honor?
I'm just going to go back and look at the PSI real quick.
He was one of 4 individuals that were breaking into cars. When they got caught, one of them fired fired a shot at the person who confronted them while they were looking in the cars at a parking lot. Put everyone on probation. They've all come back, Judge.
I guess my concern is that there was obviously a gun and a shot in the underlying
I
offense,
do recall Mr. Harrison not being the shooter. I think we were able to figure out who,
but he's in another gun. I mean, another car with somebody with
Yes.
another gun.
and Mr. Randall's been revoked and sentenced to 8 years. He had a drug case, a new felony. So which is why his was a little bit more.
Look at something else. Do you happen to have the PC for that? The new,
For his new event,
Bad ID.
yeah,
I do, Judge.
thank you.
I also have the report from Mr. Randall's charges from the same stop. If you're asking as far as where going was,
Yeah, that's
Mr.
what-
Randall's lap as he ran from the vehicle and fell out as he ran.
Obviously, I'm just having some concern.
I understand her.
Yeah, obviously we're all over. Can't tell you how over we are with guns. And the fact that this is the second out past curfew with in a car doing whatever you're doing that you shouldn't be doing with another gun.
I will state, Judge, it was at about 6 o'clock in the evening. I don't think it was past.
Oh, it was?
No,
I'm sorry. I thought I read
it was-
something
it's-
about curfew. That was
Not this one, Your Honor.
Okay, thank you, Mr. Nick. I don't guess it really matters what time it is. And the other three that have already been revoked.
Mr. Randall received 8 because he was in possession of a firearm.
So was he one of the original
I think so, Judge. I do know that.
co-defendants under the underlying case as
I
well?
believe that's why he wasn't supposed to be hanging out with him. And then
That would probably.
there's
be- It'll have in here.
yes, Your Honor, he's one of the original
Okay, I'm not gonna,
co-defendants.
yeah. I'm not gonna accept 5. Not if you're already on probation with the same person for aggravated robbery with 3 guns in that car, another gun in this car. If he got 8, then I would consider that, but at this point,
We'll discuss it.
I'm over all of this gun stuff. So I'm gonna, I'll keep, I guess, the paperwork for now. If y'all come up with an agreement,
Yes.
otherwise it's a motion to revoke. I don't have to accept any agreements. It can just be up to me and we can have a hearing if we have to. But I'll just keep it for now. I can make an adjustment if you guys come up with something different.
Okay.
All right.
Thank you.
Go back. All right, sir, you're Austin Talbot. You want to switch with Ms. Malfino, please? Thank you. And Mr. Talbot was previously in court, entered pleas of true in a motion to revoke his probation to counts 1 through 6, is on probation for aggravated assault. It was a 5-year deferred probation that he received in March of 21. And then a 5-year term for burglary of a building, as well as a misdemeanor driving while intoxicated. And I've received the updated precedence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Okay, so the burglary of the building and the DWI were both, they were actually first. He was on probation for that when he was placed on probation for this case. Those are
Expired.
expired. So we're currently just on the aggravated assault, which technically expired, but the motion kept it open, so we can do whatever we want on that one, correct?
Yes,
And you both had an opportunity to review that report.
We have, Your Honor.
yes.
Any additions or corrections?
No corrections.
Ms. Malfino?
No, Judge, other than the fact that, I handled all of these cases before this court. The burglary of the building involved the Little League, down in Lake County, if you'll recall. Obviously, it was quite some time ago, but we were all here. And I do have notes reflecting the, level of fear of the original complainant. I have not had the opportunity to study in depth the original PSI, but I know the court has it as well. I just ask you take those things into consideration in addition to the fact that with those prior the DWI here and other history here, he has subsequently pled true to a new offense. I know that's more argument than addition, but that's all I have, Judge. And unless the probation department, and this gentleman is here for Ms. Broussard. I thought it was going to be Ms. Broussard, but I'm happy for him to add anything.
And what's your name for the record, sir?
Mr. Broussard, Dallin Broussard.
That's what I thought.
Yes.
Okay.
I was about to say, I thought that was, yes, nice to see you, sir. Do you have anything to add to the updated report?
Nothing to add. No, ma'am.
Okay, and what is the status of that?
It's pending. He has a court-appointed attorney in that county. It's up north. The only discussions they've had as of right now is that it looks like they're gonna offer him probation, but nothing has occurred yet. He's got another court date,
July 21st.
July 21st.
24th.
We believe the case will be resolved on that date. If the outcome of that date makes a difference to the court, we'd be more happy to reset this until just after that next court date. But we do believe that the outcome is going to be probation there.
I mean, it's still a misdemeanor, but it's the second, so it's a class A, I guess.
That's correct.
All right, go ahead, Mr.
I would say, Your Honor, since we were here last, the plan was for Mr. Talbot to be able to continue to go to work where he's working. He moved in the kind of this process and the court allowed him to transfer and work there. But since we were here last, his child or his son's been in the hospital pretty much the whole time. We do have a letter here. He came from the hospital yesterday. His son's in the Texas Children's Hospital. He has not been able to work since he's been here. He has not made a single payment since we were in court last. He has not really been able to work either since we were here last. So unfortunately, he's just dealing with his son's medical condition, and that's all I've been able to do as far as financials is concerned. Of course, the only thing he pled true to was basically the financials and this new offense, which occurred out of the county. So there's a few technicals along with that.
So what's your,
Judge, what we're asking the court to do is consider either continuing his probation. I believe he's already reached the expiration date, but for this, he would have successfully concluded his probation. But because of this, we would ask the court to extend his probation, which has there's a lot of time left that the court could extend, or just reset and see what the outcome of the DWI is going to be. But I do believe it's probably going to be 2 years probation with interlock requirement.
Ms. Malfino?
Judge, I will defer to the discretion of the court because he has not had any other violent type of issues and because he has that issue with his child, which of course I know everyone's sympathetic to, whatever you think is.
What was the date of the offense of this DWI second? When did that happen?
I don't remember. It's like a year, almost like half a year.
May of 25. All right, so here's what I'm going to do, Mr. Talbot. I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Well, let me ask this. Do you have an interlock device on your vehicle now?
I'm not driving. I have a handheld.
You do?
Yes, ma'am.
Okay. And you've agreed not to drive?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that. I'm going to extend your probation by 2 years. I am going to order that as a condition of your probation, you enter and successfully complete the JCDI program. I understand that without driving and with having issues with your son, that could be difficult, but it's going to be required regardless of what else is going on.
Is that his probation was transferred to Angelina County? Is that something that Angelina County will do?
If they have, most counties have some type of program that is similar. And so whatever similar program they have, I would be willing to order that I'll have the probation officer look into that, but it has to be more than just, testing and stuff like that. I want an actual program. And if they don't have one, then get back with me. We're gonna have to figure something else out. This is the last opportunity you're going to be given here. You've been given a whole lot of opportunities. It will not matter what else is going on in your life. If you are unsuccessful after today, you will be looking at prison, and it's between 2 years and up to 20 years. So you've got to think of not just short term with what's going on with you and your family, but long term to be able to be around as well. Do you understand?
Yes, Your Honor.
All right, so there was no agreement on this, and so you do have some rights to appeal. I can't imagine why you would want to, but I'm going to hand you that, Mr. Galmore, if you guys will sign off on this real quick and give him that bottom copy, and then just talk to probation. Today, Mr. Broussard will let you know what you need to do so that he can look into whatever program they have up there in that county. What is that, Diboll County, or is Diboll Angelina County? Okay, we'll check into that. Thank you, sir. Thank you for being here. Good luck to you.
Thank you, Judge.
Thank you.
That's fine. Judge, his priors make him habitual by law, but he didn't receive even half the time he is on this case on those.
All right, sir, are you Donald DeRusso? And will you kindly waive the formal reading of the indictment?
I will, Your Honor.
Mr. DeRusso, in cause number 26 DCCR 0758, you're charged with the state's going to proceed on count 1 only. It alleges that you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 9th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. DeRusso is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. Good luck to you, sir. You can go back with the bailiff. Oh, wait. And I am making an affirmative finding of a deadly weapon. Right, he was after the bailiff.